Thank you all so much for joining us for this evening's public information session on the Bureau of Land Management's proposed grazing rule. My name is Leah Baker, and I am the Acting Assistant Director for Resources and Planning here at BLM headquarters. We really appreciate the opportunity to connect with you, our important stakeholders, in our efforts to streamline our grazing regulations. We're going to do three things today. One, we're going to outline the proposed revisions. Two, we're going to explain their purpose. And three, we're going to discuss how you can provide input on this proposed rule. We're revising these regulations to make it easier both for the BLM and livestock operators to respond quickly to changing conditions on the land. The BLM manages approximately 155 million acres of rangelands across the United States in accordance with our mission, which is to sustain the health, diversity, and productivity of public lands for the use and enjoyment of present and future generations. Livestock grazing is an essential activity on many of these lands and is supported by a framework of laws and regulations, including the Taylor Grazing Act, the Public Rangelands Improvement Act, and the Bureau of Land Management's Organic Act, which is the Federal Land Policy and Management Act. These laws ensure that grazing is conducted in a manner that supports land health and balances multiple uses. The existing grazing regulations have served us well for decades, but evolving needs, environmental concerns, and advances in scientific understanding require that we revisit and revise certain provisions of these rules. Our goal is to improve administrative processes and strengthen land health standards, making them more responsive to today's challenges. We hope that this presentation will be helpful for you as you review the rule and prepare your comments for submissions on regulations.gov. More on how to do that later. Again, we're so pleased that you're here and interested in this effort. Your input on the proposed rule is essential for ensuring that we create a final rule that makes sense for the rangelands that we manage, the livestock operators who use them, and the American public. Okay, now I'm going to introduce my colleagues who will be giving today's presentation. Our first presenter will be Stacy McIntosh. Stacy is the Deputy Assistant Director for Resources and Planning, again here at BLM headquarters. She'll be giving today's presentation along with Marlo Draper. Marlo is the Division Chief for Forest, Range, and Vegetation Resources. And at the end of our presentation, we'll also have our colleague Seth Flanagan helping field questions and answers. Seth is the Acting Deputy Division Chief for Forest, Range, and Vegetation Resources. Thank you all again for taking the time to be here this evening or this afternoon, depending on where you are. Stacy, please, the floor is yours. Take it away.
I hit the button. Good evening. I am Stacy McIntosh, the BLM Deputy Assistant Director for Resources and Planning. Thank you all for being able to attend this informational meeting to discuss the BLM's proposed grazing rule. While the BLM implements a mission grounded in multiple use of public lands, grazing is a historical and foundational use for the agency and occurs on BLM lands in just about every state in the West. In this presentation, we'll briefly discuss the rulemaking process, and then Marlo Draper will walk us through the proposed regulations, explaining the reasons for the regulatory action we are taking and describing section-by-section revisions. We'll talk about providing feedback through the regulations.gov commenting process. There will also be a question and answer period after the presentation. So if you have questions as we go through slides, feel free to use the Q&A button at the top of your screen. We will answer as many questions as we're able to. Please note this webinar is about our BLM proposed grazing rule, and we will not be answering questions about other subjects. Next slide, please. We wanted to begin this presentation by briefly explaining the rulemaking process. Rulemaking is a formal process that any federal agency must use to create, amend, or repeal regulations. During the process, the product that is being worked on can be referred to as a rule, a rulemaking, or regulations interchangeably. They basically mean the same thing, but technically, while still in draft and final form, they are rules, and once fully executed, they become regulations that are published in the Code of Federal Regulations, or the CFRs. The rulemaking process has 4 broad steps. The first is to identify the need to create new, revise current, or repeal existing regulations. The revisions that we are currently making to the grazing regulations are part of the BLM's overarching deregulatory effort, specifically in response to Secretarial Order 3419, delivering emergency price relief for American families and defeating the cost of living crisis. The real effort begins next, compiling information and preparing text. The proposed rule, or Notice of Proposed Rulemaking, also referred to as the NPRM, is the official document that announces and explains the agency's rationale and presents the proposed regulatory changes. All proposed rules must be published in the Federal Register as our official notification to the public and to give you an opportunity to submit comments. The proposed rule and the public comments form the basis of the final rule. BLM will read all public comments and consider and address substantive comments when preparing the final rule. Once the final rule is published, it becomes effective no less than 30 days after publication in the Federal Register. To read and review the proposed grazing rule, you will have to access the Federal Register. That is where the official proposed version of the rule resides. We will provide a direct link, but you can also access it by searching for Regulations for Grazing Administration exclusive of Alaska. Next slide, please. Okay, so once you open the link to the proposed rule, you're going to see a lot of introductory text. Both proposed rules and final rules begin with a preamble, which is basically detailed information about the proposed regulatory changes. The summary gives a very broad overview of what the rule is intending to do and includes key information regarding how the public can comment, the date when comments are due, and methods that can be used to submit comments. It also provides contact information should you have any questions. The main body of the preamble contains the supplementary information section. This is where the BLM provides a detailed description of the proposed changes, including background information, the legal authority, and purpose of the rulemaking. Next, there's a section-by-section analysis of the proposed revisions, which includes a narrative explanation of why the changes are proposed. This section is important because it details our reasoning behind each edit being made. The last section of the preamble is procedural matters, which are statements of how the proposed regulations may or may not apply to other required federal policies or laws. The preamble is signed by the responsible federal official, in this case, Lanny Erdos, our acting Assistant Secretary for Land and Minerals Management in the Department of the Interior. Directly after the signature, the proposed revised regulations in their entirety are presented. So if you're reviewing the proposed rule online, you have to do a lot of scrolling to get to the regulations themselves. Or you could download a PDF from the Federal Register and jump to page 26868, which is page 17 of the PDF file. Next slide, please. So why does the BLM believe that we need to revise the grazing regulations? First, we need to make sure that the regulations are relevant to today's grazing operations. The last major revision of the regulations was in 1995, 31 years ago. Given changing conditions on the ground, we've identified the need to build some flexibility for both operators and our BLM land managers into the regulations. We also need to align the regulations with court decisions, amendments to the Federal Land Policy and Management Act, which is the BLM's Organic Act, and guides overall management of public lands. And we also need to align the regulations with Government Accountability Office findings that direct us to ensure consistent compliance and transparency within the grazing program. To that end, we have updated definitions for clarity, consistency, and to improve transparency. Finally, this update proposes changes that will allow us to achieve efficiencies in various administrative actions. Next slide, please. Now I'm going to turn it over to Marlo Draper, who will explain revisions to the regulations in more detail. Take it away, Marlo.
Thank you, Stacy, for that informative overview of the rulemaking process and why we are all here today. I will provide highlights, not a comprehensive overview of all the proposed changes, as you can review the rule in its entirety online, as Stacy has mentioned. I will provide highlights of the proposed changes in 4100 definitions, 4110 qualifications and preference, 4120 grazing management, 4130 authorizing grazing use, 4150 unauthorized grazing use, 4160 administrative remedies, and 4180 fundamentals of rangeland health. Next slide. Starting with definitions in 4100, where we are proposing changes to certain terms, including removing the definition of conservation use. This is to be consistent with the court order from the 1995 rule. Revise base property to include livestock facilities that can serve as a base of operations in addition to the current land and water ownership. We remove livestock and kind of livestock and add production-oriented livestock to guide parameters for issuing grazing permits and updates regulations on permit issuance. We add the term beginning rancher to establish qualification criteria that affords mentoring and expands qualification beyond sons and daughters. We add the term grazing authorization as a catch-all term to include permits and leases, since permits and leases are so similarly managed. Also in 4100, we add the definitions for prescribed, targeted, and temporary non-renewable grazing uses. Moving on to qualifications and preference in 4110. 4110 qualifications and preference refers to how applicants qualify for a grazing authorization preference, how applicants' private land meets the capability qualifications called base property, how grazing preference is transferred to a new or changed grazing applicant, and also how we change permitted use. The proposed changes include, in the next slide, we added production-oriented livestock as a mandatory qualification. Operators can lease their base property. So we propose to extend the minimum term of base property leases from the current 3-year minimum to 5 years to achieve administrative efficiencies. We create an exception for name change updates when no terms and conditions in the permit are changed. We also propose that when there is a reduction in active use, those animal unit months, AUMs, they will be held in suspension and not canceled. Our next slide, we will cover grazing management, section 4120. Grazing management refers to how we manage livestock on the range within the grazing allotments. So basically, the management of grazing allotments, including through the development of allotment management plans or equivalent types of plans. 4120 includes our required cooperation with other federal and state land management agencies and tribes in the administration of laws and regulations related to livestock management. It also includes the installation and maintenance of improvements to rangelands, such as under range improvement permits and cooperative range improvement agreements. So a few highlights of the changes in 4120 include proposes updates to allotment management plans to include functional equivalents and also to reflect the current practice of incorporating these plans into a permit's terms and conditions. Revises requirements for consultation, cooperation, and coordination, also referred to as CCC, for clarity throughout the regulations. As an example, since we normally engage with the Resource Advisory Councils, RACs, on matters at larger scales than an allotment, we remove the requirement for CCC with RACs, but CCC is not precluded. We also clarify the regulations on water rights on public lands based on applicable state laws. So we defer to state law. Moving on to authorizing grazing use in 4130. Authorizing grazing use refers to the application process for grazing permits and discusses the authorization terms and conditions, including developing and modifying terms and conditions, such as those that are mandatory. And we define and explain other types of authorizations in 4130. Changes in 4130 are highlighted in the next two slides. Production-oriented livestock operations are required to authorize grazing. We now propose to allow for temporary use adjustments within 21 days before or after permit dates, providing the flexibility needed for planning and responding to seasonal changes and circumstances. Aggregate billing is available for small allotments where there are 50 or fewer AUMs. We propose to reduce the instances for mandatory consultation, cooperation, and coordination requirements, providing greater flexibility and responsiveness. Proposed changes include incorporating FLTMA authority that allows BLM to continue to prioritize grazing permit renewals based on the allotment or permit standards and available funding for required environmental analysis. Also, we rename crossing permits as trailing permits to reduce confusion because of the similarity between the two. The next slide, please. Oh, actually, can we move back one more slide? Okay, we definitely don't want to miss these highlights. So we remove the special grazing permit provision for indigenous animals, making them subject to the same requirements as standard grazing permits. We also expand who may work with the permittee to learn the business, including grandchildren and beginning ranchers. And one additional change to cover in 4130 is that no fee would be charged for a trailing permit unless livestock trail for more than 24 hours. Okay, the next section we will cover is 4150, unauthorized grazing use. 4150 pertains to the management of instances where the presence of livestock is not authorized. It defines unauthorized presence of livestock, such as grazing without a permit, and whether an instance is intentional or non-intentional. Includes procedures for managing violations, damage assessments and fees, livestock impoundment, settlement, and disposal. Changes in this section respond to the Government of Accountability Office findings from the 2016 report. The changes that we're making that respond to this report include requiring unauthorized grazing documentation regardless of circumstances, introduces a category for non-willful incidental violations, allowing BLM to handle these less formally than more serious violations, improves settlement procedures, including the potential for exempting a non-willful violation, and allows for an operator to contest a willful violation charge. 4160 pertains to administrative remedies. These are the processes for managing protest and appeals of grazing permits and leases decisions and range improvement authorizations. It also covers Part 4 that pertains to the department's general hearings and appeals procedures for grazing cases. A few changes here to highlight include expands authority for the authorized officer to issue a final decision without first issuing a proposed decision, such as where permits that are for 50 or fewer AUMs. And another example is for rangeland management wildfire decisions under Section 4190. It also proposes to modernize decision service methods so decisions can be posted online in addition to current mail services. We've standardized a 20-day protest period from the current 15-day period. The proposals update appeal language for alignment with Office of Hearing and Appeals, including the recent regulatory changes. An appeal automatically stays the decision unless BLM or OHA finds cause to enforce it, such as with full force and effect decisions for emergency resource conditions. The last section we will highlight is Section 4180, the fundamentals of rangeland health. The BLM proposes to expand the application of the fundamentals of rangeland health and standards beyond grazing to other land uses. Next. This rulemaking includes removing subpart 4180 from the grazing regulations and moves the fundamentals of rangeland health to part 1700 for the evaluation and achievement of the fundamentals of land health across all BLM programs. Therefore, establishing the fundamentals of land health and standards for program administration in Part 1700, this enables the BLM to more effectively assess land management impacts and conditions across landscapes and guide management decisions. Rapid landscape scale analyses are proposed to provide a framework that would expedite BLM land health evaluations and decision-making. Land health evaluations and causal factor determination outcomes would guide all land uses and management decisions. The proposed rapid landscape scale assessment and land health evaluations are intended to inform how uses are managed rather than dictate whether a particular land use may occur. Okay, so that concludes our highlights of proposed rule changes in the grazing regulations. I will hand this back to Stacy for more information to share on how we will proceed with our question and answer segment today, as well as information on where you can find the rule and how to comment on the rulemaking at regulations.gov. Thank you.
Thanks, Marlo. Hello again. The question and answer portion of the webinar will begin shortly. Please use the Q&A menu at the top of your screen to submit a question. If you can't see the Q&A menu, you may need to update Teams or use the desktop app. As a reminder, we will only be answering questions about the BLM proposed grazing rule. Please also note that any questions asked during this informational session are not comments on the rulemaking. However, they will help us to understand where we may need to provide additional clarifying information. Key questions and answers from the session will be added to the existing grazing rule frequently asked questions section on the BLM's Rangeland Health webpage. Next slide, please. And here is probably the most important information: how to provide comment. Online comments must be submitted through regulations.gov. On the regulations.gov webpage, search for 1004-8 AE82, and you need the dash. It's very important. You then need to click on the docket tab and click the title Revisions of Grazing Regulations Exclusive of Alaska, which will give you the docket details. On this page, click a blue box, Open for Comments, and then comment. From the Federal Register page, you can click on the green box labeled Submit a Public Comment, which will open to 3 selections. Select the top line labeled Revisions of Regulations for Grazing Administration Exclusive of Alaska. When submitting online, we recommend that you compose your comment in Word and then cut and paste it into the comment box. You can also submit your comments via mail or other delivery service such as FedEx to Bureau of Land Management Director, 1849 C Street Northwest, room 5646, Washington, D.C., 20240. Next slide, please. Here's a copy of what you will see in regulations.gov. You can see that we have searched for 1004-AE82. You then need to click on the docket tab and click the title Revisions of Grazing Regulations Exclusive of Alaska, which will open a page that will give you the docket details. Then there are 2 more blue buttons to open, one that says Open for Comments and then Comment. All right. So now we're going to move into our, thank you very much for participating in our presentation. Again, if you would like to ask any questions, please put them in the Q&A menu, and we will begin responding to those comments in just a second. We'll leave this up for a little while in case anyone would like to write down the address. Okay, so now I'd like to have Marlo and Seth join me. Very well. And we'll start the Q&A portion. Thanks, Marlo. This first question, however, is for Seth. How does the proposed rule change rangeland health standards?
Well, for decades, rangeland health standards are what we have used to as guidelines to keep public lands healthy, really, and they've been used mostly for grazing. The BLM is now proposing a broader approach by expanding the use of the land health standards not only to grazing management, but also to all BLM management programs to ensure that public lands are healthy, productive, and resilient, regardless of the use that we manage. The proposed rule would establish rapid landscape scale assessments, standardized data collections, and step-down evaluations to identify causal factors and when standards aren't met. BLM would then take appropriate action within 2 years to correct those and meet those standards.
Thank you very much. And what would happen to the existing land health regulations at 43 CFR 4180?
Thanks. Yeah, the existing regulations would move to a new part, 1700 in the Code of Federal Regulations.
And Marlo, how does the rule treat wildland fire-related decisions?
That's a great question, Stacy, and thank you so much for asking. The proposed rule expands targeted grazing as a fuel reduction tool and allows certain wildland fire management decisions to take effect immediately when those are intended to reduce wildfire risk when vegetation poses a wildfire risk. So as an example, linear fuel breaks and the reduction of invasive annual grasses. Thanks for asking.
No problem. And Seth, if the audience has more questions after this meeting, how do they ask those additional questions?
We are getting lots of questions coming in, so hopefully we'll be able to answer a lot of them, but we may not get to all of them. And so the best way to get additional questions asked is to email us at BLM_grazing_rule@blm.gov, or you can also leave a voicemail at 208-373-3818. And someone on our team, will respond to those questions and make sure you get the information you're looking for.
And will there be an opportunity, Seth, to communicate with federally recognized tribes and Alaska Native corporations on a government-to-government basis?
Yeah, there is actually a virtual meeting scheduled for June 23rd, during which BLM will provide information regarding the proposed rule revisions to Native American tribes, Alaska Native corporations. And in that presentation or meeting, the tribal government, they'll get information through that meeting, but then also have the opportunity to contact BLM with questions, comments, and also to request specific consultation. Those requests, the best way to provide those are also through those same email address or phone number that I provided just a couple minutes and seconds ago.
Sounds good. And the email is BLM_grazing_rule@blm.gov. It's very important.
Yep.
So Marla, why is BLM changing the appeal process so that appeals automatically suspend decisions unless BLM places them in full force and effect?
Well, BLM is making this change to assist in the development of the administrative record so that permittees and other interested parties are set up fairly to pursue both any administrative appeal they want to pursue, as well as any request for judicial review of a grazing decision. This change would return the grazing rules to how they used to operate.
Excellent. So we found out earlier that the rule updates the definition of interested publics in some decisions. How will the public stay informed or participate, Seth?
Thanks, Stacy. I think it's important to recognize that the proposed rule does not reduce public participation overall. Instead, it modernizes how the public stays informed and participates with BLM. Key engagement mechanisms remain in place and in some ways become more consistent and accessible. So some of these examples of way the public can stay informed include the NEPA process, which is always a great way for the public to stay informed and engaged in BLM decision-making. The proposed decisions also will now be posted online for public access, rather than only being mailed out to interested publics that are on file. Interested public can protest proposed decisions. That's a lot of alliteration.
Yeah, it is.
Within the 20-day protest window. So there's still that opportunity. And then appeals remain available to any adversely affected party. Of course, there is still the opportunities and requirements for tribal engagement and consultation. And interested public status is still available. It's just more clearly defined. So the proposed rule clarifies that to be an interested public, an individual or group must have a cognizable interest in specific allotments or a specific allotment.
Excellent. And Marla, why is BLM offering aggregate billing for small permits, and how will this change annual billing for our ranchers?
Well, we've talked about it early on in the presentation that we are looking to achieve administrative efficiencies. So saving time is saving money. This option provides billing efficiency and cost savings as billing occurs once for a small 10-year permit rather than each year. Small permits are considered those that authorize 50 or fewer animal unit months. This aggregate billing is also available for larger permits should those operators want an opportunity to opt in for aggregate billing.
Okie doke. So along those same lines, how does aggregate billing address possible changes in the grazing fee, and can they be refunded?
Unfortunately, the fee for permits and leases issued under these proposed revisions would be based on, well, basically it's a no. They wouldn't, they're not refundable. But they would be based on the average value of the grazing fee for the 10 years immediately preceding their issuance. If the BLM were forced to process refunds for those fees, it would negate the efficiencies gained by using the aggregate billing approach.
Excellent. And also, Marlo, are bison allowed as long as they prove to be production oriented?
The rule as proposed would not be based on species, but rather on meeting the production-oriented mandatory qualification and production-oriented livestock. And this means animals when they are being used as part of an operation to provide outputs for various purposes such as meat, milk, fiber, or other products. And it also includes any animals when they are being used to assist with management of other animals in connection with such operations. This would include horses that are used to assist with cattle management, as an example.
Thank you for that important clarification. Seth, what is a landscape scale assessment?
Good question. Landscape scale assessments provide a way to measure land conditions, really at a broader or landscape scale, right? At a larger scales. In comparison to the site-specific assessment, say at the allotment level. They require the use of multiple sources of information, such as field-based data and remote sensing. The results will then be used to help inform those localized and specific evaluations and decisions. So the rule also defines landscapes as mosaics of interacting ecosystems. So not specifically for a fixed acreage to those assessments, but really how the landscape and the ecosystem works together.
All right. Thank you. And Marlo, how will the Bureau measure the output of operations to ensure they are production oriented? What baseline has to be met from an output standpoint to avoid arbitrary decisions and ongoing increased litigation?
So the proposed rule offers a definition of production-oriented livestock. We are soliciting public comments as to whether and how to refine that definition, including whether to establish standards in the rules that would help us evaluate that criteria.
All right. Thank you very much. Thank you all for all of your excellent questions. And I think at this point, we're going to end our presentation because I don't think we have any more questions that we can answer at this time. I again want to thank all of you for joining us. And I'm not sure, Leah, do you have some closing comments?
Thank you, Stacy, and thank you to everybody who has joined this evening, who has stuck with us for the presentation. Thank you to my colleagues who provided the information for you all on how the grazing rule is proposed to be changed, why we're proposing the changes, and how members of the public, like all of you in attendance, can provide your comments. Thank you again. We really appreciate it. We can't make these regulations work without public input. And again, as mentioned earlier, if you have questions, we've provided information throughout the presentation for how you can ask those questions after tonight, how you can comment. And we also encourage you to contact your local field office if you have specific questions about a specific application. Thank you all very much, and we hope you have an excellent evening.